Thank you all. Could you please have a seat? We're going to get started with our first afternoon panel. Again, my name is Chesa Boudin. I'm the Executive Director of the Criminal Law and Justice Center here at Berkeley Law School. I'm super appreciative of our co-sponsors. Worked very closely with the Berkeley Journal of Criminal Law on making this possible, with the Paper Prisons Project, and with the generous support of Kecker, Peter, and Van Ness Law Firm. For those of you who are just joining us, you have QR codes on your tables, which will allow you to sign up for CLE credit. You also have QR codes on your tables, which will take you to a Google Drive folder where we have slides, bios of our speakers, and other information that you may want to follow up on today's symposium. I know we have a full agenda today, but for those of you who just can't get enough of Racial Justice Act work, don't fear. There is another awesome symposium coming up in about a month at Santa Clara Law School. So make sure, we've got some of those folks in the room. They can tell you more about the agenda. We will also be including information about how to sign up for that symposium in our Google Drive folder. So those of you who want to sign up for the next symposium, I'm sure they will cover different topics and build on what we talked about today. You'll be able to do it that way. If you need to get on Wi-Fi, it's an open network. You don't need a password. You just have to click that you agree to the terms and conditions. I think that's it for my housekeeping. I am really thrilled to have a panel of folks with us today who are expert in data science and criminal justice data in particular. And I say that in part because of how critical a role data plays in so many of the Racial Justice Act claims that those of you in this room are thinking about bringing or have already begun to bring in courts. But also because, as everybody in this room is well aware, one of the great things about being a lawyer, particularly being a public defender, is that you continue to learn. You learn from experts on DNA and on ShotSpotter, and you learn from experts on absorption and elimination of alcohol and so many other areas. And the Racial Justice Act has put all of us in a position where we have no choice but to learn from and with folks like the ones on this panel today. We're going to start off today with one of our colleagues here at UC Berkeley, Professor Mia Bird. She's just down the street at the Goldman School of Public Policy, and her research focuses on criminal justice reform in the intersection of criminal justice, health, social safety net policies. Prior to joining UC Berkeley's faculty, Professor Bird worked at the Public Policy Institute of California. I know we have representatives from them with us in the audience today as well. While there, she created a criminal justice data system that standardized and integrated individual level data from 12 different county systems, representing 60% of the state population. She did it with data from a couple of different systems that she was able to integrate, state level correctional and justice systems, as well as local county systems. These data tools allowed for the monitoring and the evaluation of the effects of a whole wide wave of criminal justice reforms in California. And she's also been able to link the data that she gathered and the data sets that she built to things like health insurance enrollment, which allowed for really robust, rigorous, data-driven research on things like the effects of the Affordable Care Act on recidivism outcomes. The work that she's done and the data sets that she's built are really unique and groundbreaking. And so we're going to start off with a question for Professor Bird. Collecting the data on race in the criminal justice system is obviously not easy. You spent years building the database that I just described. Can you talk to us a little bit more about where the data comes from? The data that everybody in this room is going to need to use in their motions, and that often they'll be fighting public records requests to try to achieve. What are the challenges for researchers and for litigants in collecting or obtaining the data that they need for their litigation? What are some of the gaps between what a lawyer litigating an RJA claim might have in their ideal world that they would want to bring to court and argue, and what they're likely to get in the real world as it exists of data. And let me load up your slides.
Thank you for this event. I just want to acknowledge how much I appreciate how many of you are here today trying to figure out how to implement this very complicated law, and really extending yourself to start thinking about how can we get and use data to better represent your clients. So just want to commend you for all of that effort. Today I'm going to talk to you a little bit about what data is out there and what kind of analytical strategies you might bring to that data to try to create the evidence base in your cases. So I want to start off with just thinking about where in the Racial Justice Act are we located for me for this presentation, and we're really thinking about these two pathways to bringing a case. We're really thinking about the idea that we can look at the jurisdictional level to look for bias in convictions, and here thinking about, is there upcharging? Do we see evidence that there are differences across racial groups in the likelihood of upcharging in a case? And second, in sentencing. So do we see differences in the severity of the sentence, whether that be prison or a local sentence, or in the length of the sentence at any given sentence location? So those are the two pieces I'm going to focus on today. And I want to talk to you first about kind of what data are out there. Now, I know many of you know that California's criminal legal system data is highly decentralized. So even within a given county, there is often very little data integration across the jail, probation, DA, and the courts. And often that data is not integrated, especially in ways that we can use for research purposes. So in ways that we could use to establish some of these differences between racial groups and some of these outcomes. And so when I thought about, what is the best data source that you could draw on without having to create an integrated data system where you link people based on identifying information? Is there a data system out there that would give you the biggest bang for your buck? I came to the DOJ's automated criminal history system. And this is really building on the data tool that we discussed this morning, building on that to think about how might you use the ACHS to accomplish some of the goals you have in mind. And that might be you, there might be some data analysts out there working in public defender's office, that might be a research partner or a contractor that you work with that can bring this data to bear on your cases. And so I want to just go over what's in this data set and why I think it's a pretty good source of data. So we have all arrests and convictions in the statewide. So that allows you to not only look within your county, but to compare to other counties, which is super helpful. It also allows you to really have a rich sense of criminal history for every individual, to the extent that you want to consider criminal history when you're looking at similarly situated people. It gives us information on the individual, their demographic characteristics, and then information on the arrest charges, the conviction charges, and the sentence. So really that most of that cycle that someone's experiencing in the criminal justice system. So I've linked below where you can go to get access to these data, to request access. You can certainly Google it, but there is a process through which you can get these data. I've gotten them, other researchers have gotten them, law enforcement agencies have gotten them. They should be accessible to you for your use. And I kind of want to talk through just what you would do with them when you get them. So if we're thinking about applying these data to these pathways, we would start with thinking about, well, in these data, do we see a difference in charges between arrest and disposition? The data do not give us filing charges, but they do give us the ability to observe where the case started, or where the arrest charges started, and where the case ended up. And so that would allow you to address that first pathway, right? To think about, well, what's that difference there? How often does it vary? Does it vary differently for different racial groups? Second, looking at sentencing behavior. Similarly, we have disposition for every case that's filed in the DOJ data. That allows us to think about, well, for a given set of conviction charges, what does the sentence look like? And how does that compare on average across racial groups? So there's a lot you can do with these data. There's certainly, if you were to bring in jail data, there's certainly important information you could bring in, like pretrial release or detention. If you were to bring in data from DAs, you may be able to enrich the data set with richer information on filing, but there's so much that you could do with this data set. As we saw this morning, you can use this data set descriptively. You can say, okay, I'm just going to look at upcharging, I'm just going to look at sentences. Are there differences between racial groups? It's a very straightforward approach. It's a very straightforward approach, but it's not one that you see often in the literature. And the reason is that in the literature, we often see efforts to address the question of similarly situated. So we see efforts to make sure that we're comparing likes to likes when we're doing an assessment of difference. And when we see this done in the literature, descriptively, we often see fairly large differences by racial group in these outcomes. And as we bring in more and more characteristics, individual level, criminal history, and case characteristics, we start to often see these differences diminish or decline. And the big question is, what are the appropriate controls to bring in? The concerns are when we're doing this kind of analysis that if we look descriptively without bringing in any controls, we're really not comparing likes to likes. But another concern is that even if we bring in many of the controls that are available, for example, in the ACHS, we have tons of rich data. But you know, as professionals, that a lot is missing there about the characteristics of the case. So we may not have full information about the case in that data set. And the concern is that we may overestimate those racial differences because we're missing some important variables. That's sort of one of the concerns in conducting these analyses and sort of drawing conclusive implications in terms of racial disparities. The second concern is that we may underestimate the bias. So when we're adjusting, we're making the decision to adjust for certain characteristics. Some of those characteristics may not be race neutral. So we may be over adjusting, we may be changing our analysis in terms of diminishing the role of race by entering in variables into the equation that are not race neutral, that are actually have embedded differences in them. Second, we may be failing to account for differences at earlier stages in the criminal legal process. As many of you know, when we think about arrests and the transition from charging at arrest to charging at conviction or files charged, we're actually basing that on arrest. So we are embedding or bringing in any disparities in the propensity to arrest into that model, into that judgment. These are some of the challenges in interpreting an analysis that is robust, that brings in a lot of variables that are important in comparing likes to likes, drawing implications for that in terms of whether there's racial bias. And so can we do this? We can certainly do this. We can think about how can we decompose the different variables, the model itself, and look at the different variables and the role that they play in changing our estimates of racial bias. And what is that underlying theory, as David Ball expressed this morning, what is that underlying theory that we are holding that helps to guide us to include some variables, to include some controls, or to exclude those controls in our analysis? So you really have to have that underlying theory to determine what should be brought into the picture, what should be left out of the picture, and also to ask yourself, what am I missing? What am I not able to see in the data that could be important? So I'm just going to pop my contact information up here if anyone wants to reach out, and turn it back over to Jesa.
Thank you so much. Well, we talk about data and the information that the lawyers in this room and in your offices rely on, in addition to the amazing work that Mia and other panelists have done with data, to get access to RJ-specific information involved years and years of public records requests and records litigation. You're going to be hearing a little later today from Emmy McLean on a panel about work she's doing and that the ACLU did, but it wouldn't have been possible without really heroic work pro bono by the Braun Hagee law firm, and the lawyer who took the lead on that, Corey DeClark, an old colleague of mine from the San Francisco Public Defender, just joined us. So if we could give him and their work litigating for years to get access to information, a round of applause, that would be really... He's underdressed as usual, but we won't hold that against him. The next speaker that I want to introduce is a graduate of UC Berkeley with a PhD in math. He's done a tremendous amount of work as an expert witness on Racial Justice Act litigation, and he's also founded a nonprofit that does a lot of service work for public defenders and their clients. Alex Carney, all the way at the far left end of the table, is the founder of PDQuery. He's an artificial intelligence researcher at OpenAI. He is the co-founder, as I mentioned, of PDQuery, which is a nonprofit that matches public defenders with early career STEM volunteers to provide pro bono technical consultations. He has testified in several high-profile cases involving Racial Justice Act claims as a math and data analysis expert. He obtained his PhD from UC Berkeley in math in 2019, and prior to that, he earned a master's degree in math, or as they would have said there, in maths at Cambridge, and in science and technology. Alex, thank you for joining us.
Thank you. Yeah, so I think I'll say a little bit about what PDQuery is and why Dana and I, my co-founder and also my partner on this, created it, and then talk a little bit about my experience. And so actually maybe to start, just had talked about having done a couple high-profile RJA cases. I think maybe more importantly, I've done a couple low-profile RJA cases. And this was kind of the philosophy starting this, that I think the typical idea of what an expert is or who is an expert is basically cuts two ways. It's either your like distinguished professor of whatever the field may be, or on the flip side, it's your like police gang expert who is an expert on gangs because they've been claiming to be an expert on gangs for 15 years. Obvious problem with that one, but problem with the first one too, which is that, as all of you are aware, I'm sure, good luck finding one and good luck paying one for all of the cases you have in front of you. And so on the flip side, if you go here on campus, in many places, walk through the halls of any of these departments, what you're going to find is a whole lot of PhD students who are very good at what they do. And then the other thing you'll know, if you've talked to some of them, is they've probably all gone through an existential crisis at some point of, why am I so deep in this thing I'm studying when there are so many real problems out in the world? And so this idea of like bring those people who are very qualified on these things to actually be useful is kind of where this came from. And so we've been slowly developing this, putting people in contact, and getting people like me out helping with these cases. I've ended up doing a lot of RJA work, and then our other thing that's been pretty popular has been medical work. I think medical records are one of the areas where really you're just lost without someone who works in that field, knows what these really mean, and can help orient you there. But yeah, very much our idea here is that more than anything, there's so many cases out there where RJA or what have you is a potential defense, and we don't want them to just end in some plea deal that was just pushed with a bunch of, as Mia talked about, like excessive or built up charges where there was no ability to push back. And so we're trying to create that being able to actually approach these as something that's more accessible. There are people you can pull in and make that. I will say we're small. I apologize to I know multiple people in the room who I owe emails to. We're doing our best and trying to get out there to grow and help more people. But do feel free to reach out. And yeah, so a little bit about my experience with this. I think one of the biggest things that stands out is how we're very much speaking different languages, and to be successful, we have to bring that together. I think one of the things that actually frames this really well is the introduction to the RJA, talking about the purpose of this and implicit bias. Having the RJA is now a tool, but it doesn't change that scenario. That implicit bias is still very hard to identify. It's very hard to put your finger on. It's hard to convince someone that it's where you claim it is. And so what that means is that to be successful as an attorney and as an expert, we really need to build a story together. So it's not that you come in and say, oh, I'm pretty sure there's bias here. Could you just throw the numbers together and boom, there it is. We've got our case. It's really, on the flip side, on my end doing the data, it's never a clean world like that, that it says, like, whatever statistics may say, it never ever formally says this is racist, or this is not racist, or this is unfair, or this is. It's always going to have an answer that's something like, oh, well, this was biased a little bit more, maybe this much more in this way, here are the error bars, this was not, this was more towards what we would expect. And we really need to work together to actually frame that into a coherent thing. I think often one of the struggles that can go very well or can go very poorly there is that, so I come from an academic background. If the court allowed me to put together a 5-lecture series on statistics and collect homework assignments and grade them and improve them, wouldn't that be wonderful, for me at least? But of course it doesn't work that way, that basically all I can add is through the direct and the cross-examination process. And so it really takes working to know what are we trying to show, what are we not trying to show, or not, I shouldn't say not trying to show, not trying to hide anything, but what is too far of a claim and what is what we're really putting down here. One thing that I think maybe is, especially being on a panel with all these people who have done very interesting, very impressive data work here, is that the standard of proof in the court versus in academic publishing is very different. And so one thing that is maybe surprising is that I've actually had the studies of some of these people up here in a sense used against me because they have all done very good work with huge sample sizes, very careful analysis with lots of variables, and I've been asked then, well, why didn't you do all of that? Like, they had a sample size of 20,000. Doesn't that mean that your analysis is invalid because you have only 350? And I want to say, yeah, well, I asked you for 20,000 and you didn't give it to me. But that aside, I think it's important to come at that knowing that you're going to be up against that challenge, that we have a very different goal, that in academia, you're putting together kind of a whole story of what's happening broadly, you're trying to really dig into the details, and there should be a very high standard of proof to really claim that across the board this is happening, here's why it's happening, here's where it's happening. And in the court, we have a defendant here who is one person and has an outcome for that one person that matters and is what we're all here to determine. And so I think knowing that and knowing that the evidence I have inevitably is going to be a smaller data set because it's tailored to this case. It's really working with what makes sense to work with here and is aiming for the standard of proof that makes sense for this case. And so I think one thing that is important here is that in doing that successfully, it requires working a little different from often how lawyers are used to in terms of like using precedent, using past cases. There's room for some of that, but I think often there's a tendency to say, well, this study did it this way, so we should do it that way. Or they had a sample size of this many, so maybe that's what a standard sample size should be. And inevitably, that's going to come back to hurt you. Those are just, if you lay out a standard, your next case isn't going to have any chance of meeting it, and that's going to just have closed a door for you. And so I think it really takes engaging in the, like, what does it mean to say more likely than not for the case, for the data we have in front of us? How can we work together so that the numbers I'm putting together and the story you're putting together of where those numbers come from, why those are the right numbers to look at versus these other ones, all play together. So I think it's really an effort of building a case together. One thing, I'll close with this, one thing I think is very funny when we started this project, to just kind of see if this idea of connecting STEM people with public defenders could work. We did a survey of public defenders. And one of the things I insisted on putting in that was a question of what's your math background? What classes have you taken? And when we looked at that, you see at first pretty much the pattern you'd expect. Like lots of people took pre-calc, decent number took Calc 1, Calc 2 starts to fall off a little bit. You get to like multivariable and differential equations. Basically, as you get to harder classes, fewer people have taken them, not very surprising. until linear algebra, which is one of the hardest math classes out there in your kind of typical course. But somehow a bunch of the public defenders said they had taken it. And I'm pretty sure what happened is they didn't all take this, but they saw the words algebra, and they saw the word linear and said, well, that's the easy kind of algebra, right? I probably took that at some point. And so they took the box and they moved on. And I think it's a very funny story, but I think it's A, kind of the dynamic we're working with, but I think B, want to point out that it's really something that is bridgeable. Like unlike the studies some of these people are working on, when I have a data set of 350 people, I can't bring like advanced research methodology. I'm bringing very core statistics to this. That maybe you're not qualified to run those numbers, write the programs yourself, but you are all able to work with me to come to an understanding on what does it mean, how do we use it, and how can we really land the point with this. And so maybe I'll end with that. Don't be afraid of the math, you can all do it. I will teach you linear algebra if you need it, and let's really land the story of where there's bias and come to justice.
Thank you, Alex. Our next speaker on the panel is Professor Jeffrey Fagan. He's here all the way from Columbia Law School. I think he is the attendee who has come the farthest to be here. So thank you for traveling 6 hours by plane. Professor Fagan has taught at Columbia Law School for more than 20 years. He's widely recognized as a leading expert on policing, crime, gun control, and race, whose scholarly research is influential in setting public policy. A prolific scholar, Professor Fagan has served on the editorial boards of academic journals, provided expert testimony, and is a sought-after commentator on policing, race, and the death penalty. Professor Fagan's research on the New York Police Department's stop and frisk practices, which found that more than 30% of the stops were legally unjustifiable or questionable, was central to a 2013 federal court decision that found the stop and frisk policy unconstitutional. Professor Fagan, you've done a tremendous amount of work on racial bias in areas like stop and frisk and the death penalty. I'm going to ask you in a moment to step up, and I know you have a PowerPoint which I will tee up for you. I'd love it if you could share with us some of the lessons you've learned from that work. And also, if you could focus in on a term of art in the Racial Justice Act statute, which I think is often subject to varying interpretations. The term of art is similarly situated. What does that mean? What should it mean to lawyers litigating RJA claims? And finally, there are lots and lots of different statistical tests out there. Some of them are in the literature, some of them are in that linear algebra class that I never took, but might pretend I took if I'm talking to Alex. It can be really confusing, even if we did take linear algebra, or if we're confused about whether we took linear algebra, it's even more confusing. Of all these statistical tests that might make sense to the experts on this panel, can you help us understand as lawyers sort of the hierarchy of tests and which ones are better for what? And I'll, with that, cue up your slides.
Okay. Thank you. It's great to be here. I lived in California 15 years. It's wonderful to be back. I've been gone way more than 15 years, but we didn't have atmospheric rivers when I was living here. It was a term of art that I've had to learn. And I want to say to Alex that we just, a year ago, actually a year ago Tuesday, testified in a death penalty challenge in Kansas, where we, together with a team of outstanding, an all-star team of experts, had a sample of about 175 cases. And somehow we managed to persuade the court, or the prosecutor in particular, that he wasn't going to win. There's no way to win based on the way that we had assembled the data. So there's a certain kind of creativity about the way that you pull together pieces of data from here and there. So it's the small, don't be deterred by small sample sizes. That's that, and for all the reasons that Alex suggested. So I guess before I step up there and fool around with slides, I wanted to say that there's kind of, the strategies for getting data out of reluctant people and reluctant agencies really, to me, it sounds like hearing a day and a half of Racial Justice Act discussion. Basically, you got to get a little lucky with the court on discovery. You need to be able to understand what you're asking for and to push it particularly to a source that you can identify, so we kind of help the court. And I admit we've been lucky. We were able to get data in New York, for example, on the policing regime because they were forced to make it public by preceding court cases. So you kind of have to build on a line of cases from other places. Might be interesting to have some kind of consolidation of all the methodologies that all you use in litigating the cases, as well as consolidation of what all the experts have done to pry data out of the agencies, and to learn how to make do with getting something a little bit less than ideally you would get. I want to propose that identifying the similarly situated status claim is it's a data problem, but it's also an identification problem. Similarly situated speaks a little bit to two different concepts of proportionality that are in case law, especially death penalty case law. One is that the punishment should fit the crime. That came out of Furman, and all you people who went to law school and study criminal law probably understand that, and maybe even practice it still today. But the second one, and it's a little bit closer to similarly situated, is comparative proportionality, meaning not just like being treated as like, but it's a combination, an intersection of the two. Does the punishment fit the crime, but also like being treated as like? And that raises the challenge, because the challenge really is identifying what's the unique contribution or role of race in producing the racial disparity. How does the data configure to produce the disparity? And then, I'm going to sort of drift over to the podium. Oh, that's not working? Okay. Should we do the slideshow part? Yeah. What's on it? Ah, okay, good. Good to go. To identify the role of race, but also to think about the narrative ways that you would think of express the role of race. And what I want to get to here is to talk about different categories or different methods of analysis of data and presentation of data, which essentially involves storytelling. And if there's one thing I've kind of learned in doing all this stuff, you're storytelling to the judge, or you're storytelling to the jury. And you have to bring them along with you to sort of humanize the data, demystify the data, and be able to tell the data, express it in a way that appeals to their natural intuitions about what inequalities mean. Comparative proportionality basically means not just like being treated as like, but it's like being treated as like when in the context of the broader data producing or disparity producing context. And that means you have to ask questions about what data do you need to tell that story? And you can tell from everything that I understand about the struggles you've had in courts with getting data, you have to figure out how to tell the story with probably less than the ideal volume of data that you have. So you have to think carefully about what's essential to tell it. What produces the disparity? That's the storytelling that you're going to do, is what are the features, what are the characteristics of the agencies and the criminal justice practices that actually produce the disparities, and how can you gather data to tell a story about how those processes work? And the third, and I think the one that's the most critical, especially since you're going to have an opposing expert, I'm going to have an opposing expert, and you have to be able to kind of identify or anticipate what they might say about your product. And be able to sort of tell your story in advance, sort of shoving their concerns, which you as an expert, you know from peer review and all these other experiences, what they're likely to say about your work. Telling the story and having the data there in a way that you can weave the story together in a narrative way is essential. So let me go through this a little bit. Which one are we using to advance? Just there. Nope. How about this? Perfect. Okay, so here's a hierarchy of tests, and it's also a hierarchy of narratives. It's a combination of two things. One is a hierarchy of tests, but the other is a hierarchy of narratives to tell the test. So when I go into court or produce something in a report, first thing I do is give the basic data. How many people of this race are subject to the whatever the outcome is, whether it's charging or sentencing or death penalty or execution or arrest, incarceration, whatever the outcome is, how many people of each race are subject to that outcome? And in a sense, it does two things. It cues up the proportions that you have to explain in your story. But the other is it actually, and I learned this kind of yesterday from the meeting that Emmy organized, that it helps you advance the claim that the burden isn't just on you to prove the disparity. You're going to be able to show data. The reason you're in court is because there's going to be a disparity. And it opens up a conversation about, well, why do I have to prove that this is disparate? Why don't you have to prove why you're not producing the disparity? Where's the burden? And I think it's interesting to use the raw data, the basic percentages to tell that. Second, and this is something that I did in a couple of court cases, and I think it works pretty well, something called the binomial probability. Or, you could say, in statistics, it's sort of a white swan, black swan test. What are the odds that, given what you know about the population you're working with and the data that you have, what are the odds in that population that you're going to see X% of those people being charged with, let's say, or charged as a capital offense, or being filed with a death notice? And it's a pretty simple statistic to run. And Alex probably run it a million times. Jack's probably run it a million times. But it basically says, look at this disparity here. You've got maybe a 1 in 20 chance of this disparity happening, which would be about sort of a 5-to-1 odds ratio, something like that. So that's the second test, the binomial probability. Very easy. You just simply run it and you say, under different configurations, what are the odds that you're going to see this happen? The third is a regression test. That's the most common. You run a model, and I'll give you a little example of that in a minute. And you basically say, what are the odds of this outcome for this race compared to another race, black versus white, Latinx versus white, other versus white? What are the odds of that happening? At what level of statistical significance? My preference is to talk about odds ratios as opposed to statistical significance, because there's such debates about significance in the literature. I think Jack might have something to say about that. I've learned to be more skeptical than I actually am from my work with Jack. So you basically say, here are all the possible explanatory variables, and here's the outcome, and here are the racial groups. What are the odds of this happening? And you are essentially adjusting the race variable, the contribution of race for all the other variables in the model. And I'm glad Mia mentioned the danger of having too many variables or too few. And this is two sources of bias, included variable bias, omitted variable bias. And you really have to walk a tightrope as an expert. And you have to explain the parsimony of your model, which gets at that, and it says just enough to prove it and not too much to obscure it. And that's an important design feature. So that's essential. So the next would be a disparate impact test, where you basically line up the two samples. Here's all the white people who are eligible. Here are the non-white people who are eligible. You line them up, two samples. They sort of look alike. The distributions might be a little bit different, but you run a test for disparate using essentially a treatment model. Is race a viable treatment explanation for the disparities that you see? That's fine. The next one to do, though, is a little bit harder, where you try and match up the people in the samples. So you match them up on all of the things that you think predict the outcomes. And obviously, apart from race, it would be age, it might be where they live, what neighborhood, poverty rate in their neighborhood, many, many other variables. Educational attainment, prior record, of course, is one of the most essential ones. So that's a disparate treatment test as opposed to just a disparate impact test. And the third one is one that's a little bit new. I borrowed the name from Sherrod Thaxton, who teaches at UCLA at the law school, who's a brilliant statistician. Sociology is a funny word these days, but Sherrod has a PhD in sociology as well as a law degree. And he calls it an endowment test, and I think that's an interesting way to think about it. And what it says is that you can't, he argues against, and I think he's right, and I've done this now a few different times and it works. You can't just say that there's race net of everything else. You have to say that race actually means more than just race. Race is the product of policing tactics. Race is the product of the neighborhood characteristics where the police are. Race is the product of an educational system. Many things load on the concept of race. And what Sherrod argues for, and I'll show you an example of it in a second, is to adjust the race data or the race marker for all of the characteristics that might produce something about race. So you're thinking of race as kind of, to go back to your high school algebra, a vector of influences. And I think it makes it contextualizes race in a way that's really essential to have a conversation about race. And this goes to the idea of, as you present data as an expert, to bringing the contextual variables in and talking about things in context and always shifting to the context. Because the disparities come from the institutions, and they come from the places where people live. So here's a concrete example. I'll be done quickly. We're asking whether or not similarly situated can be translated into a model of comparative proportionality. I argue to present the data first as case-level variables. Second would be some context-dependent variables or independent variables, but mostly dependent. What's the characteristics of the county or the characteristics of the neighborhood within a city where people live? And in particular, crime rates invite police. Police will then produce a range of prior offenses. And so whether or not the difference in priors and the way you talk about priors is the product of policing, not a product of race. And so it's important this is part of the contextualization of what race effects mean in RJA. And then the third is you introduced a combined analysis of the two. Now the math is complicated, we're not going to go into the math, but your expert most likely knows how to do it. Certainly, I think it's something that's very, very common now. We've used it in policing data, used it in death penalty data. I've seen it done in health data and in a variety of other data sets. And what you produce then is an estimate for each of the independent levels, the case level of variables, and then the context variables, and then you marry the two. And the math is hard, but it gives you a pretty clear, what we call an average treatment effect or an average disparity effect. It's an average disparity. You can present it as the disparity, but again, I think discursively, in order to sort of bring your judge along as a friend, talk about odds ratios. So we live in a world where every 30 seconds there's a FanDuel bet on television. If you watch it, I hate it as a lifelong sports fan. But you get a sense about what are the odds of somebody doing X within the next quarter of the football game. And so you can bring along using odds ratios that you produce out of any one of these regression coefficients or models as a way to discursively present the information. So quickly, here's a model. This is a regression model. And so you can see race sitting in the middle, but everything is thrown into the, let's say we're analyzing charging decisions. All the data that's relevant is thrown into there. So this is a case level model. And you can see the variables. They're typical variables. That could be the selection of the variables is up to what's good in the data and the preferences and how you want to tell the story, basically. So this is simple. But it gives you a sense about race in the context of all the other variables that are competing with it to explain the disparity. There's good and bad about it. There are people who are very critical of regression models. If it's done right, it's a very powerful model. But for the most part, I think we can do better, and that's what I'm trying to argue for. So here's an endowment model. So the first part is the case level data. So essentially you run a regression about race. You load these variables onto race, and then the adjusted race variable then is used to predict charging or death sentencing or whatever the outcome variable is. This is a little new, but it's out there in the literature. Second, then, you run the same regression with the context variables. So these are just examples. I think it's up to what data are available and how you want to tell the story about the conditions under which the cases arise. But you can load these, whatever the variables are that you think are the best ones to tell the story, these are the neighborhood or county level variables that explain it. One thing I would put in there, so for example, you could think about misconduct data on police, if you can get it. How many lawsuits under 1983 or Monell claims were filed against the police? Give you a sense about the biases in the police that are helping, or the problems in policing that are helping to produce the outcomes that you see. If you wanted to be really ingenious, you could talk about what the size of the police budget is per capita. And look at that, compare one county to the next, which shows you the investment in policing, for example, in the neighborhoods that actually would produce the range of prior offenses. And that's contributing to the disparity that you see. So that's the second level, that's the context level. And then you do the third. And the third is you put them all in the same model. Again, we're not going to talk about math, but this is the math to do this is you basically two separate models, and then you join them, and then you use the combined adjusted variable to predict what the outcome is. And so that's why the little curve is on the end for the marrying the two. So that's the model. It works really well. It's been used, I used it in Stash House case in Chicago. I've used it in New York in the policing case, the policing litigation. Couldn't use it with 167 cases in Kansas, unfortunately. I really wanted to, but I couldn't do it. But if the data are available and your sample sizes are enough, you actually can do it. And I want to close with just simply saying, here's a bunch of, just think about the way that you would divide the world into the two case versus context variable sets. And these are just examples. Your experts probably are very creative in thinking about it. They probably have a theory in the back of their heads, the back of their minds about what's producing the disparity and what the role is of each variable in producing it. You knowing the context in which you litigate should work together, and also people in the NGOs in your neighborhoods, in your counties, can work with the expert to help identify what the relevant variables are, measure them as best you can, and go to work with it. But again, it's storytelling, and I think when you present, when you have your expert on the stand, or even in the report that they're writing, think about it as satisfying two audiences. One is warding off the critiques of the opposing expert. The other is bringing the court and maybe the jury along with the story that you're trying to tell. So that's my story.
Thank you. Thank you, Jeff. I know a lot of the references to math were over my head, but several people on the panel were nodding vigorously as he was talking. And that's good, because our next speaker is one of them, Professor Jack Glaser from down the street at the Goldman School of Public Policy as well. Professor Glaser is a social psychologist whose primary research interest is in stereotyping, prejudice, and discrimination. For example, he investigates unconscious, the unconscious operation of stereotypes and prejudice using computerized reaction time methods. And he's investigating the implications of such subtle forms of bias in law enforcement. Among other things, Professor Glaser is currently working with the Center for Policing Equity as one of the principal investigators in a study that's funded both by Google and the National Science Foundation. And the study is focused on trying to build a national justice database of police stops and use of force incidents. Professor Glaser, one of the things that is kind of so unique about the Racial Justice Act is its explicit reference to implicit bias. Traditionally, courts have required, not just in the criminal context, but in civil litigation as well, that any discrimination or racial bias claim prove discriminatory intent, not simply disparate impact. And of course, the Racial Justice Act is a departure from that otherwise well-established standard. It says explicitly that implicit bias is enough for defendants to seek relief. I know that it is often easier to identify and talk about implicit bias in the kind of research studies that you do than it is in an individual specific case. Can you talk to us a little bit about how lawyers can put together an argument about implicit bias in a specific case, if that's even possible? And what does the Racial Justice Act really mean when it talks about disparities between groups?
Thank you, Jason. Thank you all. I'm really happy to be able to be here, and especially with these esteemed colleagues. So one thing I want to add to my bio, it said that I use computerized reaction time methods to study unconscious bias. And I just want to note that I've been doing that for 30 years. And based on that 30 years of knowledge accumulation, I want to clear one thing up that is sometimes disputed, and that is that implicit bias is real. And by implicit bias, I mean thoughts, memories, feelings, beliefs, stereotypes, and prejudices that reside in our memories, even though we don't necessarily have subjective access to them, and that can be automatically activated in our memories and cause us to make biased judgments as a consequence of that. It's real. The science is exceedingly robust. There are thousands of published studies on implicit bias. And the science also shows that measures of implicit bias correlate with measures of explicit bias for similar constructs. So if you ask people to tell you how much they feel positively toward black or white people, and you take the difference between those scores, that will correlate modestly with an implicit bias measure that involves measuring how quickly people are able to categorize words or faces or names that have racial associations when they're paired with positive or negative stimuli. And in addition to that, more recent research is showing that implicit biases measured through these computerized reaction time methods are predictive of actual discriminatory behavior. And there's a whole slew of studies. I'd be happy to share some valuable references in that regard. Now, all of that said, because implicit bias tends to be measured using these computerized reaction time methods, it's a noisy construct. And what I mean by that is that essentially what we're trying to do is make an inference about the strength of the mental association that people have between this racial group, this gender group, this political party, and that thought or feeling, that positivity or negativity, or that association with criminality, for example. We're making an inference about the strength of that based on the difference in reaction speed that people have to hit one button or another on a computer monitor. And we're typically looking for average reaction time differences in the ballpark of 50 to 100 milliseconds in the implicit association test, which you may have heard of. So we're making an inference about the activation of mental concepts neurologically based on fine motor and to some extent gross motor responding to a set of stimuli that are presented in randomized orders, so different orders to everybody who's doing the task. So it's going to be inherently noisy, and yet, in spite of that, these measures tend to correlate with things that matter to us, like decisions about who to call in for an interview based on the racial signals in their name at the top of a resume. And so they're noisy, but scientifically quite robust. The challenge is that those measures themselves are not designed, nor should they be, I feel strongly about this, and I'm happy to take questions on this, nor should they be used as a diagnostic tool at the individual level. So that's kind of the bad news. People who study implicit bias, by and large, are not comfortable with the idea of using one of these tests at a diagnostic level. They're very reliable at the aggregate level, and I'm going to talk about how that possibly provides us with an opportunity to use some data on implicit bias to leverage some traction on an RJA case. It's also true, as the legislation states, that everybody has implicit bias. We don't all have equal implicit bias, and we don't all have biases toward the same things, and some of us have positive attitudes toward groups, and other people will have negative attitudes toward those same groups. So there's variation in those biases, but by and large, implicit bias is ubiquitous, and that's because it reflects how we remember things, how we process information. It's very normal human cognition to be able to perceive and encode and store and retrieve information without having to exert any conscious effort to do that. In fact, we would be fairly paralyzed if we weren't able to do that. So they're normal, they're real, they're pervasive, and there's some variation. The original formulations, the original theoretical discussions around implicit bias weren't, oh, this is cool, we can measure it and it will correlate with things. They were more about, this is real, it's ubiquitous, and that's the baseline that we need to understand people are operating in, that we're all vulnerable to these implicit biases, and they set the stage for us to activate and apply stereotypes and biases when we encounter somebody from a stereotyped group. So, all of this given, to get right to the core of the question, I do not believe that it's going to be a fruitful venture to try to demonstrate implicit bias at the individual level given the circumstances of a particular case. And that is in part because of what I just said, that the measures are quite noisy and they're really not designed to pick up or serve as a diagnostic tool. That's kind of the bad news, but on the other edge of the sword is the potential for arguing, again, that they create this generic vulnerability. And then there is research using one of the tools of implicit bias research, which is something called Project Implicit, which is a website where people, many of you I suspect, have gone to carry out the implicit association test, and you can opt into providing data or just doing it as a demonstration. But we now have, I wish I were more directly involved, the field of social psychology now has millions of observations of people who have done implicit association tests. And among those millions, there are millions who have just done the simple, most commonly referred to black, white, good, bad association test. And what some researchers have started to establish is that county level, and I think in some cases census block level, variation in the intensity of implicit bias. So you can use the Project Implicit data to calculate average implicit bias at the local level. That one study shows that that's associated with higher levels of average implicit bias in a county is associated with greater racial disparities in police stops. There's another study showing a relationship between implicit bias and greater disparity in police use of force, racial disparity in police use of force. So there is, down the road, I think, the potential for using implicit bias data from Project Implicit, and ideally someday from a more randomized sample, to make claims about the ambient level of implicit bias in a particular location that could complement some of the other data that we see based on the actual policing behavior and the charging decisions and the prosecuting and sentencing, et cetera. So that's one of the positive possibilities. I also think that, just generally speaking, the data are robust enough to support the claim that I started with, which is that implicit bias is real and that it's pervasive, to be able to change the sort of prior assumption going into any discussion about whether there was bias in a particular case, to assume that bias was present and operative. And I don't think under the RJA we can flip the burden of proof, but there's still sort of internal calculus that various legal decision makers make about burden of proof. We know that burdens of proof are fairly subjective. And so if we can make the argument that bias is more likely than not, all else being equal, and the implicit bias research demonstrates that, I think, quite overwhelmingly, that should help with making the argument that given the direct evidence we have in a particular case, the likelihood that bias was operative is relatively high. With respect to disparity, I think I'm going to punt on that because I have a feeling it's going to come up again, and I'm on a panel with Jeff Fagan. I'm not going to pretend to be the guy who can speak about what disparity is.
Sure you can.
Please join me in thanking Jack for his comment. We have about half an hour for questions. I'm going to urge and remind people to use the microphones at the front of the room. There's one at each corner of the stage. We need to do that not so that those of us on stage or in this room can hear, but so that the couple of hundred people who've been joining us throughout the day via Zoom are able to be fully participant. They're not able to ask questions, but they are watching closely, so closely that one of them just sent in a comment in response to Alex's discussion of linear algebra to a public defender known to many of us in this room, who said that he did in fact take linear algebra in college. And, wait for it, and it completely beat him and showed him he did not have a future in math or maths plural, which is why he's a public defender today. So.
We're here doing RJA now, so he does have a future in math with help.
While we wait for folks to come up and ask questions at the microphones, please don't be shy. We have half an hour. I will just say that I know all of the people on this panel have been overwhelmed with requests to be expert witnesses. They cannot say yes to every request. And I know that part of what they have to do is think strategically about cases where they and their time can have the greatest impact. And the panel that's coming up after this one is going to talk about impact work in RJA. But in the meantime, let's take advantage of the fact that we have this amazing collection of really, really brilliant folks with deep expertise in a space that is intimidating to many of us to pick their brain. I'm just going to start by asking each of you to share or respond to something that you learned from the presentations your colleagues made. Maybe start with you, Alex, and we can work our way back down.
On the spot. Let me think. I think really interesting seeing from Jeff's presentation, I think was a really useful breakdown of kind of the different levels of analysis. And I think one thing, I think I'll definitely use that in my work going forward. And I think it's also useful to then think through, this doesn't mean you have to, and as you said, doesn't mean that you're going to do all of these at every point, but I think is useful to kind of think through, what do I have to work with? Where does that fit in here? And then maybe what would I do with the other pieces, or like, why is those being missing not necessarily going to sink the case, but what can I do to fill in that story in other ways? And so I think piecing your story together in where do I have data, where do I have other kind of background and implicit bias or what have you that can make that together, I think is a really nice framing.
If others of you want to respond to things your fellow presenter said, feel free. Otherwise, we do have a line of questions as well.
I'm just going to say that I don't know that this is something I learned, but I feel like it was very poignant how Jeff talked about model specification. And it's this fundamental challenge. And I'm reminded of a study where researchers sent a particular data set out to something like 27 or 29 different research groups. And the data set was on football, European football penalties, and skin tone. And it enabled people to run calculations to see whether there was a relationship between the darkness of the skin of the player and the number of penalty flags or cards that they got. They sent this out to something like 27 different groups. It was a multivariate data set. It had multiple variables, but they were all the same that they were sent out, including that one variable of number of penalties. And I think they got 27 different analyses back. And these were all like serious research groups. And so that's one of the challenges that we're all going to face, is that you have to have some assumptions underlying what's right in your modeling, in your mathematical modeling, in your regression modeling. And you want to strive for parsimony, as Jeff said. You want to explain as much as possible with as few variables as possible, but you don't want to be vulnerable to arguments about omitted variables, so you failed to account for this or that. And there, that's almost as much art as science. Jeff has set some standards and some posts in the ground, and there's, so there is precedent for that, but it's no easy task, and there has to be a lot of thoughtfulness put into it. It's great to see a collective of people thinking together about that.
So to translate what I think Jack is saying, partly what Jack is saying.
Who are you translating for?
For myself,
Okay.
basically. Clear stuff up in my head. You need a causal story about your causal story. And I think that's really maybe explicating that at the outset of the project is really the most important thing to do. But I did want to ask Jack a question. I'm agnostic about implicit bias. It's always disturbing when I do an implicit bias test. It's me, sorry. That find out how biased I am. But I wanted to ask something that always skeptics always say to me, and that they say is, well, sure, everybody's biased. What's the relationship? How can we predict explicit bias or discriminatory behavior from knowledge of a bias test? I'm sorry, I don't know what's going on.
I don't know if it's you.
Up there. It's me.
Maybe they're all.
It's the atmospheric river.
I think the microphone's biased against you.
Yeah. It's just trying to create an ominous background sound. Yeah, so maybe you were looking at my notes over my shoulder because I neglected to say, I started to say that the original theoretical and causal story that people were telling, including Patricia Devine, who wrote a definitive paper on this subject and published it in 1989, which in 1993 felt like eons before to me. In that initial formulation, she was arguing that implicit bias, automatic biases, as she called it at the time, were ubiquitous, that we all have them. And the distinction she was making, which she and her colleagues have followed up on in subsequent research, was what people do with that and the burden that people have on themselves to try to override those biases. And so, and what she and others have found is that there's another interesting psychological construct called motivation to control prejudice. And they can measure that with questionnaires. I've tried to measure it using computerized tasks. And the basic finding there is that, again, you know, the implicit bias is pretty pervasive. Some people have it stronger than others. What really determines how people act or how they respond on a questionnaire measure is whether they care about how biased they are. Now, that's the first stage. The problem with that is that implicit biases are so automatic, they activate so rapidly, and they are so difficult to control that you need not just the goal to control them, but you need strategies, known strategies. You need the cognitive capacity to do that, and you need to not be sufficiently distracted or stressed out or tired in order to do that. So, nevertheless, all else being equal, people who are motivated to control their biases exhibit less bias in spite of their implicit biases. And I think that's a really important part of the story.